Today we have with us Nancy Neerman from the Education Debt Consumer Assistance Program. Um, so we are going to get started. If you want to go to the next slide. And in case I didn't introduce myself, I'm Sharon Campo, supervising attorney here at Legal Services of Long Island. I supervise our consumer debt project here in Suffolk County, along with Legal Support Center for Advocates and the Suffolk County Pro Bono Project. So this is our agenda. We'll just go over a little bit about Legal Services of Long Island in the event you're unfamiliar with our organization. Um, then Nancy, I'm going to pass it off to Nancy, and she's going to go over important updates, the strategies for tackling student debt, repayment options, guidance for borrowers, other discharge options, delinquency, default, and collections, and then, of course, some links that are useful. Next. Okay, great. Thank you. So Legal Services of Long Island is Long Island's largest provider of free civil legal services. We do handle over 6,000 cases every year. And that includes direct representation, phone consultations, brief service or referrals. We have 3 different offices, Hempstead, Islandia, and Riverhead, and we do have case handling staff, including attorneys, paralegals, and social workers, and we do have partnerships with community agencies, whether it's Brighter Tomorrows, or the Community Service Society, or Empire Justice, just to name a few. You can go next. So here are our locations and phone numbers of all of our offices, and our website is legalservicesli.org. So if you are a client and you need services, or if you're an advocate and you need to make a referral, the best thing to do is make the referral or go to the office closest to you. So Nassau County would go to Hempstead, and Suffolk County would either go to Islandia or Riverhead. Next. So we have about 20 different units in all kinds of different areas of law. We do not handle criminal, only civil, but we do have a domestic violence project in both Nassau and Suffolk. We have a child support defense project only in Suffolk. We have a multitude of disability and health related projects, whether it's assisting folks who are severely mentally ill, or assisting folks who are in Medicaid managed care, our education and disability rights, our disability advocacy project. Our housing units are in both counties, assisting folks who are at risk of being evicted, or our foreclosure project, assisting folks to save their homes from foreclosure. And then other areas include a consumer debt, also education debt as well, which is what we're going to be talking about today. Our education debt consumer assistance program paralegal is Allison. If you want to say hello to everybody.
Hi, my name is Allison. I work with Vivian, the
Uh,
supervising attorney.
Awesome. Thank you, Allison. So we have a program that assists folks who have student loan debt or higher education debt, and we can assist folks who need help in that. We have our Veterans Rights Project, our Public Benefits, Senior Citizen Law Project. So all of our different units are on our website, and you can see descriptions of each and every one of them, so to get a better idea of everything that we do. Next. And then, of course, we have our Legal Support Center for Advocates, which we have myself, Kathy Lucidi, and Hannah Fitzpatrick. So this is a specific program for advocates, whether it's someone who's a social worker, medical personnel, guidance counselors, someone who works for an elected official, anyone who's assisting a client or a constituent or a patron and is curious as to whether or not it's a legal issue that we would help out with. Rather than make a dead referral, you can give us a call and see if it's an issue we can handle, or if we can give you legal information for the client or an appropriate referral. So our extensions are for advocates only. We do not speak to clients because we are not case handlers. So feel free to give us a call if you're an advocate. We also host community trainings like the one we're doing today. We have another one coming up on veterans rights, which I will be posting about soon. And we do publish newsletters every so often, the ones in print that we just did publish one recently, but also I send out advocacy tips every month to give different tips on everything that's going on in the world or on Long Island. And let's see next. And at this point, I'm going to pass it off to Nancy.
So thank you so much, Sharon, and thanks again to Legal Services of Long Island for allowing us to present this important information. And there is going to be a lot of information today, so feel free to follow up with Allison or Vivian at Legal Services of Long Island if you have additional questions or you need a one-on-one session. So we're going to start by talking about some of the most recent updates that are impacting the student loan system. And of course, the most recent one would be the government shutdown. So there are things that are still functioning, and then there are other things that are not quite functioning right now. In terms of what actually is working, loan servicers are, you have to remember, these are the Nelnets, the Advantages, the Mohila. These are third-party organizations that are contracted by the by the U.S. government to service your loans. So they are not direct employees of the Department of Education. They do have appropriations at least for a little while, and so they are continuing to perform the services that a servicer typically performs, which is collecting payments, doing the billing, processing certain types of applications like income-driven repayment applications, consolidations, requests for forbearance and deferment, that type of thing. If the shutdown is prolonged, some of those services may change. The one thing you can be probably fairly sure of is that you're still going to have to make your student loan payments. The FAFSA application, if you're applying for school, that is open for the 2026-2027 academic year. So these will be for people that are looking to enroll for the fall of next year. That application is open. It opened a little bit early on September 24th. So you can submit your FAFSA. New loans and Pell Grants for the current semester, that's the fall of 2025, should have already been dispersed for the most part. There may be some people who are trying to get loans late in the day that might be impacted by the shutdown. But otherwise, you can apply for the FAFSA. The loans for next year will not be dispersed until late summer of 2026. And by then, presumably the shutdown will be over. Now, there are certain things that are impacted and that could be delayed. So the Department of Education has furloughed most of its employees. We've heard anywhere from 85 to 90%. And that includes the Office of the Ombudsman, who are the ones tasked with basically resolving any kinds of disputes or complaints. They are pretty much non-operational at this point. It was already difficult, frankly, to get disputes and complaints funneled through them. So right now, pretty much everything is on hold. And then there are certain programs, certain discharge programs that the Department of Education is responsible for managing, including things like the Public Service Loan Forgiveness Buyback, which we're going to talk about a little bit more later. Other things like TPD, BDR, and actual discharges through PSLF, or maybe possibly even through income-driven repayment forgiveness. That's a little bit uncertain at this point. So you might get notifications that you have met all the requirements. The actual discharges may have to wait until the shutdown is over. And then, of course, the big news in the last few months has been the One Big Beautiful Bill Act, or OBBBA. This was the new tax and spending cut bill that was signed into law by the president in July of this year, and that is making some sweeping changes to the student loan system, including changes on borrowing limits, repayment options, changes to forgiveness or income-driven repayment forgiveness, elimination of short-term relief programs, and we're going to spend a lot of time actually going over the impact of the OBBBA on the student loan system today. The one thing that and this is interesting, that the bill does not touch is the Public Service Loan Forgiveness Program, or PSLF. It doesn't touch it in any substantive way. The only place in the bill that it's mentioned is to allow the new income-driven repayment plan called RAP to be eligible for that plan. Having said that, and remember, PSLF has its own statute. It is law, and it is up and running under the current statute. However, there is a process called the negotiated rulemaking process. This is a tool that the Department of Education uses to make regulatory changes to programs. And this process is underway where they may be looking to limit or change the definition of what constitutes a qualifying employer. And that could affect borrowers in the future that are working for certain types of organizations. We're not going to spend a lot of time on that right now because the rules are not finalized. And if they are finalized, they will not go into effect until July of next year. And frankly, I think there'll be probably some challenges in between now and then if that rule does go into effect. But for now, PSLF is operating, barring the shutdown, it's operating the way it should normally operate. And then, of course, we have to talk about the end of the SAVE plan, where we've been talking about this for a while now. But so the SAVE plan, just as a reminder, was an income-driven repayment plan that was introduced by the Biden administration back in 2023. It was going to be by far the cheapest repayment plan for the vast majority of federal student loan borrowers, not everybody, but for most people. It hit some, it was challenged legally in April of last year. And in July of last year, a federal appeals court placed an injunction on the Department of Education, preventing them from billing anybody under the SAVE formula or enrolling new borrowers. So anybody that was enrolled in the plan as of July of last year, which was about 8 million borrowers, was placed into a forbearance. It was at the time a non-interest bearing forbearance, and it did not time spent in that forbearance did not count towards forgiveness. Now, the end of that forbearance is dependent on the resolution of the court case, which is still pending. We haven't had a decision. But whether this plan disappears as a result of the legal challenges, which we still don't anticipate there's going to be a favorable outcome from a legal standpoint, it is going to be eliminated as a result of the new budget bill. So one way or another, the SAVE plan is not going to be around in the future. Now, the current forbearance on the SAVE plan, these forbearances kept getting pushed back because, again, the end of the plan and the end of the forbearance is really reliant upon the court decision, which hasn't come yet. So the latest end date for the forbearance, I believe, is January 31st or early February. We've seen some like wacky dates as well, going all the way out into 2028. I don't think that that's correct. It doesn't really matter. At the end of the day, the SAVE plan is going to go away probably within the next 6 to 7 months. Time spent in forbearance continues to not count towards loan forgiveness. And the interest holiday, which everybody enjoyed when the injunction started in July of 2024, ended in August. So starting August 1st of 2025, interest is accruing in your account if you're on the SAVE plan. Now, that doesn't mean that you have to make payments. You can still stay in the plan and not make a payment. But just know that the interest is piling up in the account. And it's estimated, the last actual number we saw was about 7.7 million borrowers still in the SAVE plan. It's probably a little bit less right now because I know a lot of people are looking to get out of this plan, and we'll talk more about this later. All right, so now let's go into what some of these new rule changes are. And I'll just preface this by saying like I said, there's gonna be a lot of information here. Some of it is a little bit confusing. If you need to follow up for an individual appointment, you should absolutely do that. So starting with direct subsidized and unsubsidized loans for undergraduate school, nothing has changed about those borrowing limits. So if you're a dependent student, you can borrow anywhere between $5,500 and $7,500 per year, with an aggregate total of $31,000 for your undergrad degree. If you're an independent student, you can borrow between $9,500 and $12,500 per year, up to $57,500 total. So that's all stayed the same. The changes come with the graduate school loans and the PLUS loan program. So direct unsubsidized loans for graduate school, if you're going for a regular master's degree, it's a $20,500 annual limit. That actually is the current limit. But there's now a lifetime limit of $100,000 for a master's degree. If you're pursuing a professional degree, like a law degree or a medical degree, it's a $50,000 limit with a lifetime limit of $200,000. Now, you may say to yourself, well, that still sounds like a lot of money. It is a lot of money, but as many of you probably know, we see many clients that have law degrees and certainly medical degrees where in excess they've got easily $300,000-$400,000 worth of debt that they've accrued in the federal system. So here's where the changes really start to make an impact. The Graduate Plus Loan Program was a program that allowed graduate students to borrow up to the cost of attendance within the federal system. So you could borrow in Graduate Plus loans the cost of attendance minus any direct unsubsidized loans that you had gotten for your graduate school, and minus any scholarships or grants that you may have gotten. So this allowed graduate students to pretty much fund their entire graduate degree within the federal system, which has, of course, its benefits. They're going to be phasing out the Graduate Plus program starting July 1st of next year. Now, there is a grandfathering clause in here. If you receive a direct loan for your graduate degree or a plus loan prior to July 1st of 2026, you can continue borrowing Grad Plus loans for up to 3 years to complete your current program of study. But for anybody that's starting from scratch, starting July 1st of 2026, basically the maximum that you're going to be allowed to borrow for a master's or a professional degree is going to be either $100,000 or $200,000, which is going to mean that some people for these more expensive degrees are going to have to find other sources of funding, which may include things like private loans. The other program that's going to be very significantly impacted by these borrowing limits is the Parent Plus program. So Parent Plus loans work in a similar way to Grad Plus loans, but they are loans that a parent can take out for their dependent undergraduate student. So these loans can only be taken out for a student to complete an undergraduate degree. Currently, parents can borrow, again, up to the cost of attendance, minus any aid that the student is receiving, either with their own student loans or scholarships and grants. But that's going to change. Going forward, there will be an annual limit of $20,000 per child and a lifetime limit of $65,000 per child. And that's including total borrowing between both parents. So it's not like you can have one parent doing $65,000 for one child and another parent doing another $65,000 for that same child. It's going to be $65,000 total for that child amongst the parents. Again, there's grandfathering. If you receive a Parent Plus loan or your child receives a direct loan before the July 1st, 2026 deadline, you can continue borrowing under the current rules. So that means up to the cost of attendance for up to 3 additional years. So the dependent, that particular child, can finish their program of study. One big caveat here for both Parent Plus loans and graduate loans, although it's way more impactful for the Parent Plus borrowers, is that even if you are grandfathered, you have to pay the loans back under the new repayment rules. And that has a big, big impact on Parent Plus borrowers, which we're going to talk about in a minute. Okay. Repayment plans for future borrowers. So if you're a student borrower, and you take any loans on or after July 1st of 2026, you're only going to have 2 options for repaying them. Right now, there's a myriad of options. There are a number of traditional plans that you can pay in. You can pay in a standard 10-year fixed repayment plan. You can extend that plan. You can do a graduated version of it. Under the new rules, future borrowers will only have one option for a standard or traditional payment plan, where the payback period is going to range from 10 to 25 years based on the size of the debt. If you don't want to be in a traditional plan where the payment is essentially like regular consumer debt, you're just based on the size of the loan and the interest rate and the payback period. If you're looking for an alternative that's based on your income, there will be one option, and it's called the repayment assistance plan or the RAP plan. And the calculation is for how much you pay in this plan is going to be different from the way current plans are calculated. So it's going to calculate payments at 1 to 10% of adjusted gross income. Those payments will be reduced by $50 for each dependent you claim on your tax returns. This is a different standard than is currently used to, it's a different and less generous standard than what is used on the current IDR plans to account for family size. There will be a minimum payment of $10. So that's even if you have zero income. You're going to be required to pay at least $10 per month. Under the current plans, if you have very low income or no income, you could actually get a $0 plan. There will be a $50 monthly principal subsidy. So if you're making your required payments and that's not enough to reduce your principal by $50, the government will pitch in the balance and reduce your principal by $50 a month. So that's actually a good thing. I'm going to just skip down because it's related to the $50 monthly principal. The other good thing about the RAP plan is that unpaid interest will not accrue on your account. So this is similar to a feature that's in the current SAVE plan that's going away, where if the monthly payment that you make does not even cover the interest, which is often the case if you have a large balance and a moderate income, under the current plans, that unpaid interest balance gets added to your account every year. And that's why people make their payments but continue to see their student loans increase, the balances increase. That's not going to happen under the RAP plan. So if your payment does not cover the interest, basically the government is going to subsidize the interest, is going to wipe out that extra interest. You just must be making whatever the required payment is on the loan in order to get that benefit. Spousal income, if you're married, can be excluded for the purposes of calculating the payment if you're filing separately. Importantly, on the new RAP plan, there is no protected income and no adjustment for inflation. Now, both of these are features of the current plans, and specifically the lack of an adjustment for inflation could be challenging if you're in a situation where your income is not keeping up with the cost of inflation. It could make it more difficult for you to make the payments in the RAP plan going forward. But nevertheless, these are going to be what the choices are for new borrowers. And then this plan, if you are not pursuing public service loan forgiveness, if you just have a very high loan balance and a moderate income, this plan you can get forgiveness after paying for 30 years. Under the current IDR plans, you get that type of forgiveness after you pay for 20 or 25 years. And as I mentioned earlier, the payment, this plan is going to be eligible for PSLF. It's probably not going to be available, however, until, well, latest probably July of next year. They might introduce it a little bit sooner, but it's not available yet. So now I want to talk about what actually is going to happen kind of with the transition, because there's different people that are sort of in different buckets in terms of what kinds of options they're going to have going forward. So we're going to start with existing borrowers, and I may refer to these folks as legacy borrowers. These would be people who basically do not plan to borrow on or after July 1st of 2026. So all your loans will have been dispersed prior to July 1st of 2026. What we're calling you, this is not an official term, this is my term, legacy borrowers, and you're going to have access to probably more repayment options than new borrowers will have. So what you'll be able to do is access some of the existing plans like Payee and ICR under the current rules until and a modified version of the IBR plan whenever that becomes available until July 1st of 2028. On July 1st of 2028, the payee plan and the ICR plan and the save plan, if it's still in existence, which it probably won't be, will be phased out. And at that point, the only current repayment plan, IDR plan, which will live on beyond July 1st of 2028, and only for legacy borrowers, will be income-based repayment, or IBR. So if you're in payee and ICR as of July 1st of 2028, you'll automatically be transitioned to a new version of the IBR plan. So what is modified IBR? The new version, the existing version of the IBR plan has an income test. If your income is high enough in comparison to your loan balance, and you're not currently enrolled in the plan, you would not be able to actually enroll in the plan. The current IBR plan also has a payment cap. If you're enrolled in the plan and upon recertification, your payment exceeds what you would pay in the standard 10-year fixed repayment plan, the standard 10-year fixed payment becomes a payment cap in IBR. Under a modified version of the IBR plans, they're going to get rid of the income test, but they're going to keep the payment cap, which means that anybody with a direct or FFEL loan can enroll in an IBR plan, and you may be able to enroll in it at the actual payment cap, which you can't do right now. Now, this modified version of IBR was supposed to be available and go into effect immediately upon the bill being signed in July. However, the Department of Education needs to fix all the systems and upgrade them, or update them, I would say, to make it so that people can enroll in IBR under these new rules, and they have not done so yet. So practically speaking, some borrowers that should be eligible for IBR may not be able to get in just yet. That doesn't mean that you can't apply. You can apply. They may hold your application in until the systems are fixed, or they may reject it and you might have to come back and do it over again. But hopefully within the next few months, they had said they were targeting winter to make these changes. That might be delayed by the shutdown. But hopefully that will be fixed and people will be able to enroll in IBR. There are also two different versions of IBR that will continue to be available to borrowers based on when their loans were dispersed. If you have any loans dispersed prior to July 1st of 2014, the plan that you're eligible for is the older version of IBR, which has a 15% calculation of discretionary income and forgives balances after 25 years. If your first loans were dispersed on or after July 1st of 2014, that's going to be calculated at 10% of discretionary income, and balances are going to be forgiven after 20 years. Now, these borrowers, whether you're a legacy borrowers, will also be eligible for the WRAP plan and the new version of the standard plan. So if the WRAP plan, when that becomes available, is your cheapest option and it makes sense, you can switch into that. New student borrowers. So these are people who take any loans dispersed on or after July 1st of 2026, even if you have loans that were dispersed prior to that date. You're only going to have access to the new standard fixed repayment plan or the repayment assistance plan. So only two options, just like somebody that's getting a loan for the first time on or after July 1st of 2026. Now, here's where it gets more important if there's any Parent Plus borrowers out there. So repayment plans for Parent Plus borrowers. For legacy or existing Parent Plus borrowers, again, you're done with borrowing any loans prior to July 1st of 2026. If you have unconsolidated Parent Plus loans and you want to pursue income-driven repayment plans, which allow you to pursue forgiveness programs, if you don't want to lose access to that, you must consolidate your loans, fully consolidate them before July 1st of 2026. If you're already consolidated, then don't worry, then you've met that part of the Parent Plus borrower rules, so you should be okay. But if you have any unconsolidated Parent Plus loans and you're not planning on borrowing any more debt on or after July 1st of 2026, you must do this consolidation if you want to continue to access income-driven repayment plans and forgiveness programs. Recent guidance from the Department of Education says that once you consolidate, you must enroll in the ICR plan and make at least one payment before transitioning to the IBR plan, which you will have access to. Once they update the systems, Parent Plus bars will have access to IBR. These rules are still being finalized through one of the negotiated rulemaking committees. They could be subject to change, but frankly, the way I'm hearing it, it may not. Like, this may be the rule. You don't have to enroll in the ICR plan and make that one payment by July 1st of 2026. You would have to do it before July 1st of 2028, however, before the ICR plan is phased out. And then if you're in ICR by July 1st of 2028, you will be transitioned to one of the modified IBR plans, depending on when your loans were dispersed. Parent Plus borrowers, however, will not have access to the WRAP plan, even if the loans are consolidated. You will not have any access to the WRAP plan. New Parent Plus borrowers, if you take out any loans dispersed on or after July 1st of 2026, these loans can only be paid in the standard repayment plan, even if they're consolidated. So basically, they've shut future Parent Plus borrowers out of having access to any income-driven repayment plan, which basically leaves you with no path to income-driven repayment forgiveness or public service loan forgiveness. And very important note for existing Parent Plus borrowers, if you take out any additional Parent Plus loans on or after July 1st of 2026, you must pay them all back in the standard plan. So you will then lose access to income-driven repayment and public service loan forgiveness programs. So this, and other forgiveness programs. So this is really probably going to, and should really be a key consideration when Parent Plus borrowers are thinking about taking out loans in the future through the federal system for their children, because you may not have the access to the forgiveness programs that you once thought you might have. Again, you might want to reach out for some help with this if you're a Parent Plus borrower, just to make sure you're on the right track. The fact is that if you need to consolidate loans, you must completely consolidate by July 1st of 2026, which means you should probably file the application no later than April 1st to allow enough time for the consolidation to actually be completed. And then this is just an illustration of what the new WRAP plan might look like compared to some of the income-based repayment plans. So in this example, I was trying to calculate what the payment cap might be based on a loan balance of $85,500 with an interest rate of 6.58%. The payment cap would then be $974. And then the assumptions that we're making in terms of family size for IBR and number of dependents for WRAP are 2 and 1 respectively. And you can see that actually at the lower income levels, except for the very, very low income levels, the WRAP plan actually compares favorably, particularly to the older version of the IBR plan. Where the IBR plans may become useful to people who are eligible for them is that if there's a payment cap that goes into effect and their income increases, the WRAP plan does not have a payment cap, so the IBR plans may become more attractive. But remember, IBR will not be available to any student borrower that takes new loans out on or after July 1st of 2026. Other changes that are going into effect. So for loans that are dispersed on or after July 1st of 2027, there's going to be some changes to your access to short-term relief programs. So you're not going to be eligible for economic hardship or unemployment deferments. Although I will say that if you are typically eligible for these things, you probably are also eligible for a very low income-driven repayment plan. And you can only be in forbearance for 9 months out of any 24-month period, which I think is going to be the more difficult component for people to deal with, because people do use forbearances when they really cannot afford any payment on their plans. So that is going to change only for loans that are dispersed on or after July 1st of 2027. So for all loans that are dispersed prior to that date, you can access these programs according to the current rules. For general forbearances, you can get up to 36 months of general forbearance on a loan throughout the life of the loan. I should make a note, by the way, if you consolidate, let's say you're an existing borrower with no a legacy borrower, you weren't planning to take out any new loans on or after July 1st of 2026. If you consolidate your loans on or after July 1st of 2026, you are now considered to be a new borrower, and you're going to have to follow all the rules of the new borrowers. So that's just something to keep in mind. Other changes, rehabilitation of defaulted loans. If your loans are in default, rehabilitation is one option to get yourself out of default. Currently, you can only rehabilitate a loan one time. Starting July 1st of 2026, you'll get 2 chances to rehabilitate a defaulted loan. And then some of these other discharge programs like borrower defense to repayment, which is a claim that you can file if you feel your school was guilty of some kind of fraudulent behavior, or close school discharge if your program closes while you're enrolled or shortly after you leave. The Biden administration introduced some new versions of these rules that would have made it easier for borrowers to get favorable responses to these claims. That's now been delayed until July 1st of 2035. And these rules are also, the Biden era rules are currently undergoing a court challenge. You can still file a BDR complaint or a closed school discharge complaint. When it comes to the BDR complaints, an older standard would be applied. If you think that your school fits the requirements of this program, you can file the application, but just keep in mind that it's very difficult to get loans discharged through BDR, and it could take anywhere from 3 to 5 years to get a decision. So you probably want to reach out for some guidance on how to file and what to do and what not to do in the process of filing, like maybe not taking a forbearance for 3 to 5 years, waiting for a decision that may not be favorable, that kind of thing. So you want to reach out for a little guidance on that. Okay, I'm going to stop there and see if there are any questions that either Allison or Vivian want to highlight.
There's one question. I think it might be good to save this one for later. It's about relying on PSLF buyback as a
Yeah.
strategy. But I think we'll pick it up
go
when we
over
get
that,
to that
yeah.
section.
Okay, Allison, anything?
No, not right now. The only question that came up is what Vivian pointed out. It was about PSLF buyback.
Yeah.
And also the general cheapness of Save in comparison to other plans. But
The general
Save is going
cheapness
away.
of what? Of what?
Someone had asked about whether Save was generally less expensive than the other income-based repayment plans, which for many borrowers, yes, it was, but like you mentioned, it's not going to be an option any longer.
You're right. Correct. Okay. So I just want to talk a little bit about sort of general strategies for eliminating debt, because after all, at the end of the day, the goal is to eliminate this debt one way or another. And when clients come to see us, they may come to us very often with sort of immediate issues that need to be addressed, like they can't afford their repayment plan, or they're having trouble switching from one plan to the other, or they're in default and they need to get out. They're on the brink of default and they don't want to get in. And of course, we're always going to address all of those questions, but we also want to leave people with a long-term strategy for eliminating the debt. And what we found after 6 years of doing this and many thousands of client meetings is that everybody pretty much falls into one of 3 buckets. The first bucket is going to be pay your debt in full as quickly as possible. So this is going to be for people who have high income in comparison to their loan balance. They can afford to make extra monthly payments or even lump sum payments. If this is your goal, the faster you pay, the less you're going to pay overall because you're saving on interest. The second strategy, which is where most of our clients tend to live, is that you basically have a high loan balance, moderate income, and you need to find a forgiveness program that you're eligible for. And when you do that, you want to basically just make the minimum required payment until such time as you are able to get your loans forgiven through that particular program. And the analysis that you want to do is you kind of look at your loan balance, and let's say it's a loan balance of $150,000, but you're eligible for PSLF, which is a 10-year path to forgiveness. You say to yourself, is there any realistic expectation that I can pay that $150,000 off in less time that I can get forgiveness? And if the answer to that question is no, this is the strategy that you want to follow, and you don't want to make any extra payments on your loans. You just want to pay the minimum until you get that forgiveness. And then the third strategy is a little bit depressing, but we have this here for a reason. It's basically to pay the minimum until you die. So this is really going to be for older borrowers who maybe have taken out late in life loans for themselves, or have a lot of Parent Plus debt for their kids, and they're either at or on the brink of retirement, so public service loan forgiveness is no longer an option for them, and they're faced with paying for 20 to 30 years, which if you're 50 or 60 or 70 could be the rest of your life. The reason that we put this here is because federal student loan debt, unlike most other consumer debt in this country, is dischargeable in death, meaning that if you, the primary borrower, dies, the obligation does not get passed down to your estate, and therefore is not going to be an issue for your beneficiaries and your loved ones. And one of the things that they did in the new budget bill as well is made that these death discharges non-taxable. So really, once you die, the burden is lifted from, is not passed on to anybody in your family. So if you're in this situation, you just want to find the cheapest payment plan that you can and make that payment until you pass, knowing that it's not going to be an issue for your loved ones. And then, of course, you always want to you're going to need to find a repayment plan, which is going to be the vehicle which gets you ultimately to your goal. And there's essentially two different kinds of plans. There's the traditional plans, which are based on the size of the debt, the interest rate, and a payback period. It's like paying back the fixed version of these plans is like paying back any consumer loan, like a mortgage or a auto loan. You make the monthly payments, after which, when you're done, you paid everything, including all the interest. Or you go into one of the income-driven repayment plans. IDR, or income-driven, is the umbrella term. Currently, those plans would be IBR, Payee, ICR. Eventually, WRAP will be in there as well when that becomes an option. I did want to say a quick word about the IDR account adjustment and the income-driven repayment forgiveness program. So income-driven repayment forgiveness offers forgiveness for anybody enrolled in one of these IDR plans after you make monthly qualifying payments, 20 to 30 years worth of qualifying payments. And the difference between this and PSLF is that there is no employment requirement for this program. So this is going to be the default forgiveness program for people who have very large loan balances, moderate incomes, but they don't have the kind of job that would qualify them for PSLF, which is a faster track towards forgiveness. The Biden administration had this one-time adjustment that awarded retroactive credit towards IDR forgiveness, which was could also be turned into PSLF credit if you file the right forms, based on a set of relaxed rules. That all that credit has been awarded already. That program is over. There was a tracker that was on the Federal Student Aid website briefly earlier this year, but that tracker has been taken down. However, it's important to know that the information is still in the system. And you can access it via this link. When you get the deck, you can follow the instructions here. You can copy the link into your browser when you have your Federal Student Aid account open, and it's going to give you this kind of ugly looking table here. You want to make sure you click the pretty print because it's even uglier without the pretty print. You can copy and paste that file. You may not know how to read it. You can reach out for somebody else at LSLI to help you read it. But just understand that that information is still there, and hopefully at some point they'll put those trackers back up. Important to remember that any credit that is accumulated towards IDR forgiveness on any of these plans, whether it's SAVE, Payee, ICR, all those plans that are going to be phased out, all that credit will not be lost. It will be transferable to the IBR plan, and to the RAP plan when that plan becomes available. All right, so now we're going to talk about public service loan forgiveness. As a refresher, PSLF forgives debt after making 120 qualifying months of payments. That's 10 years worth of payments. Only payments on or after October 1st of 2007 count towards PSLF, because that's when the program started. You must have direct loans. You must be in an IDR plan, or some payments in the standard 10-year fixed plan will count as well. And then the employment requirements are that you must work an average of at least 30 hours per week for one or more qualifying employers, which are typically nonprofits and governments. The payments don't have to be consecutive. You must meet the employment requirements at the time that you submit your application for forgiveness. So if you're at the 120, or the next application that you submit is going to get you to 120 qualifying payments, make sure that you're still employed at the time that you submit that application. Otherwise, you're not going to be able to get that final hurdle. And then one of the most attractive features of this plan is that forgiven balances are not taxable at the federal level, and they're not taxable at the state level in New York either. And you may hear things and read things about the fact that student loan forgiveness is going to be taxed starting in 2026. That does not apply to PSLF. That only applies to the income-driven repayment forgiveness program that I talked about a little while ago, and maybe some other programs which don't immediately come to mind. But PSLF is its own statute. It's a separate statute, and that is not taxable ever at the federal level. And there's no talk of, I've not heard any talk about changing that just yet. So now we're going to talk about the buyback that I know there were some questions about. The PSLF buyback, PSLF buyback is a program that was introduced in 2023. Although it was the IDR account adjustment that I mentioned kind of made it unnecessary until very recently. And what this program allows you to do is to purchase PSLF credit for months that you may have spent in a disqualifying payment status. And what the big one right now, of course, is all those months that people have been spending in the safe forbearance, which is a disqualifying payment status for PSLF, are eligible to be bought back under the PSLF buyback system. However, you must meet certain requirements before you actually do the buyback. Number one, you must have 120 qualifying months of employment on record. So not qualifying payments. If you had 120 qualifying months of payments, you wouldn't need to buy anything back. So you must have the 120 qualifying months of employment on record, which means that you probably will have to submit a PSLF certification form to update your employment. And then the months that you buy back must get you to 120 qualifying payments. So if you, let's say, for example, have 110 qualifying payments right now, but you have 120 qualifying months of employment on record, if you have 10 ineligible payments that you could buy back, you would be able to do the buyback at this point. You can't purchase months prior to consolidation or months spent in a school deferment, a grace period, or a default. And the payment, how they're basing the payments, it's a little bit, let's say, opaque when it comes to what they're going to do for folks in the save plans, but generally they're going to be based on what the payment you would have been making on the plan was prior to you going into the disqualifying status, and what the payment is you're making, is it that you might be making after you come out of the disqualifying status. And there's different rules also depending on how much time you're going to be looking to buy back, whether you're looking to buy back less than 12 months or more than 12 months. So what happens is when you submit the request, they will send you eventually they'll send you a letter with a proposal. And it will tell you, this is how much you're going to have to pay per month. This is how much you're going to have to pay in total. You have to pay the total within 90 days. And you can either accept that or reject it. It's relatively easy to submit the request through the PSLF reconsideration portal on your federal student aid account, which you will get when you'll get the link to this when you get this deck. And then all you have to do is select the PSLF buyback option, and then you sit back and wait. And one of the issues with the buyback is that it's a labor-intensive process, processing these forms, and the department has not assigned a lot of people to doing this. And as a result, there's a big backlog. And our estimates at this point is that it could easily take more than a year to clear that backlog. I also don't believe that these are being processed during the shutdown because all those folks have been furloughed. The one thing that you can continue to do, however, is you can continue to submit your PSLF certification forms. These are the forms that verify that you've met the employment requirements for PSLF. Remember, and just because a lot of people get confused about that, remember that this is this has nothing to do with the amount that you pay monthly. It has nothing to do with the income-driven repayment plan applications that you may submit that may switch you to a different plan or recertify your current plan. This is simply to verify that you've met the employment requirements for the PSLF program, and you must have at least one of these forms on record with the Department of Education for every qualifying employer that you've had since October 1st of 2007 or later, if your loans were dispersed later, if you want to get an official qualifying payment count. So you generally want to submit these forms annually or whenever you change jobs. There's no deadline for doing it. You know, if you haven't ever submitted it, but you've got PSLF qualifying employment, you can go back and get yourself caught up by having your previous employers sign the forms. We do strongly suggest, however, that if you do submit them, that you use the PSLF help tool from your studentaid.gov account and request an electronic signature from your employer. That you will see your counts update very, very quickly when you do this. If you submit them with manual forms, it can take quite a while to get a response. Okay. I want to go into a little bit of guidance because I know we're getting very close to the end, and I want to make sure I sort of get through some of this and allow a little time for questions. So just some general guidance for people in the current environment. What should you do? If your strategy is to repay your loans in full, then a lot of these changes really don't have a huge impact on you. You might be considering a traditional plan, such as the standard plan, or an extended plan if you have access to it. And again, if that's your goal, you want to pay as aggressively as possible and get the loan paid off as fast as possible because you'll save money on interest over the life of the loan. If you're pursuing income-driven repayment forgiveness, so that's IDR forgiveness, that's that 20 to 30-year forgiveness without an employment attachment requirement. There are currently 3 income-driven repayment plans that are available to those who might be eligible. That's the IBR plan, and there are 2 versions of that, PayE and ICR. Again, PayE and ICR are going to be phased out over the next 3 years. You should look at IBR first, because that's the plan that's going to exist for or going to survive for legacy borrowers after PayE and ICR are gone in 2028. If IBR is the cheapest, we recommend that you enroll in IBR now, as long as you can make those payments. And just remember that the qualifying payment credit for IDR forgiveness accrued in any of these plans will be transferable to IBR or WRAP. So if PayE or ICR is cheaper for you now, you can enroll in those. When they expire in 2028, you would then be transitioned to IBR or possibly WRAP if you qualified. If you're pursuing public service loan forgiveness, if you're already enrolled in IBR, PayE, and ICR, continue making those payments. You can earn credit towards PSLF on those plans. If you're currently in the save forbearance and you can remain in the save forbearance if you need to. There are some legitimate reasons why you might want to stay in save. If you think that your income is going to decline next year and you don't want to base a payment on a higher income, you might want to wait until next year before you submit a plan to an application to switch plans. Or if you think the WRAP plan is going to be the cheapest option for you and you need to wait for that, you could remain in save. But for a lot of my clients, they're itching to get out of it so they can continue to earn credit towards PSLF. You should submit the IDR application as soon as possible. Again, similar recommendations. As for IDR forgiveness, we recommend looking at IBR first. But if pay or ICR are your lowest payment options, then by all means, you're going to get PSLF credit for that. When you submit an IDR application, you generally are placed in a processing forbearance for 2 months, and processing forbearances are eligible for up to 2 months worth of credit for PSLF. So if the application doesn't get processed in 2 months, you could actually earn some PSLF credit by just submitting the application. And then submit a buyback application if you're eligible for it, but you might want to not necessarily wait for you don't want to solely rely on the buyback to get you to public service loan forgiveness, to get you forgiveness, if it's going to take a year or more to process the application. So what you might consider doing is submit the buyback application. There's no downside to doing that if you're eligible to do it, but also transition into a new income-driven repayment plan, make those payments, and just see what gets you to forgiveness faster. And then selecting the WRAP plan, which is not available yet. The WRAP plan may be a cheaper plan for you versus the existing repayment plans if you still have access to those. Remember, existing borrowers can switch to the WRAP plan once that becomes available. At the time that I did this presentation, if you chose the WRAP plan as a legacy borrower, it wasn't clear that you'd be able to switch back to income-based repayment. But it seems like you may be able to do that. We'll have to wait to see the final rules, but that looks like there will be some flexibility for legacy borrowers to go back and forth between WRAP and IBR. Remember, payments in WRAP will count towards PSLF and IDR forgiveness. If you're pursuing PSLF and WRAP ultimately becomes a cheaper option, enroll in the WRAP plan. It makes sense. If you're pursuing IDR forgiveness and WRAP is cheaper, here's what you have to consider. Under the existing plans like IBR, PayE, and ICR, the forgiveness period is going to be either 20 or 25 years. Under the WRAP plan, the forgiveness period is going to be 30 years. So even though the payment is cheaper, you could be paying 5 or 10 years longer if you switch to the WRAP plan. So that's going to have to be part of the consideration. Parent Plus borrowers, I kind of went over all of this a little before. Just remember, there's a sense of urgency if you're a Parent Plus borrower and you want to retain access to these income-driven repayment plans and forgiveness programs. You just need to make sure that you're positioned correctly ahead of this July 1st, 2026 date. So feel free to reach out and get some counseling on that. I'm going to stop there, and we may not get to these last sections. We may have to sort of table that for another day, but because I just want to go over any remaining questions. So I'm going to open it up to Vivian and Allison.
Yes, there's a question asking for clarification on how buyback amounts will be calculated depending on how long the chunk of time that you're requesting to buy back is.
Okay, so this is my understanding, and we probably would in the future we'll have something a little bit more concrete. But if this is just starting to come to light right now, what they're saying is if at this point you were to be buying back less than 12 months worth of credit, so that would and let's say you were enrolled in the SAVE forbearance, they will calculate what you would have had to pay just prior to being in the SAVE forbearance, but they're going to calculate it based on the old revised pay-as-you-earn plan because they're not allowed to use the SAVE calculation. If you were enrolled in any of the other plans, like let's say IBR, PayE, ICR, prior to the 12 months, then they would use the payment that you would have been making in those plans prior to going into the disqualifying status. If it spans more than a year, my understanding is that they're going to start asking for tax information. So they're going to ask for your tax information for both years so that they would then calculate the payment that you would have had to made, you would have been making in each of, this is if it goes over 12 months. So they would be looking at your tax records from before, from the first 12 months to the second 12 months. And then I think I don't know whether they take an average of the two payments between the two, or they calculate sort of a weighted average. It's something to that effect. I think the key message here is that some people are staying in the save forbearance or want to wait for the buyback because they think they're going to get a significantly cheaper payment by doing it that way, and that may not be the case. Right now, I mean, I saw a client yesterday who's been in the save forbearance for 17 months. So that's clearly over the 12-month mark. If they were looking to pay that back, if they were looking to do that all through buyback, it seems like they would have to submit their income information for the first 12 months and then the second part of that, the next 12 months, which means that it's somewhat equivalent to just submitting an application right now to apply for another plan and having your payments being based on your 2024 tax returns. So the thought that you should stay in the save for or wait for the buyback because it's going to give you a considerably cheaper payment may not be right. We're going to do more work on this, but that's kind of what I can tell you for now. I hope that was
Yeah, I think that addresses it. I don't see any other questions at the moment.
Okay. Do you want me to go on here, or are we out of time? I'll do whatever you guys would like me to.
I think if folks want us to continue, which we did have a comment, yes, please continue. That's totally fine with us.
Okay.
We have time.
Yeah, I mean, it's actually not going to.
And it is recorded, so if anyone has to leave, they can always catch the recording.
Okay. And there's not that much more to go, so it shouldn't take too long. I just wanted to say a quick word about the total and permanent disability, or TPD discharge. This is a program for people who have a mental or physical disability that essentially prevents them from earning a livable wage. Doesn't mean that you can't work at all. This was a program that used to be managed by Nelnet. They transitioned it to the Department of Education. I would not say that transition has gone particularly smoothly. There's been a lot of bumps and hurdles, and there's a lot of bugs in this new system. Slowly but surely, they seem to be maybe working their way through these bugs, and we're starting to see these applications after long periods of non-processing. These things are starting to come through. But again, you can reach out to LSLI if you need help with submitting a TPD discharge application. And then I did want to say a quick word about delinquency, default, and collections, because it's sort of on people's minds right now. And remember, there was a long period of time during the COVID period and beyond COVID, really, where borrowers did not have to worry about delinquency. They didn't have to worry about their loans going into default, and they didn't have to worry about involuntary collections if they were not in default during, before the pandemic. All of that has changed now because we're pretty much beyond all the COVID relief. And so now delinquencies are going to have an impact on you. You're going to be considered delinquent if you miss one payment. If you're 30 days delinquent, then you're going to be hit with some late fees. After 90 days, the delinquencies are reported to the credit agencies. And after 270 days, you are at risk of default. So how can you address these past due payments? You want to contact the servicer and ask for a retroactive forbearance. That would bring your account current. They won't always do it, but in many instances they will, particularly if it's only a couple of months. And if it's less than 3 months, then you'll prevent the delinquencies from being reported on your credit report. You do, even if you request a forward-looking forbearance, at some point you are going to have to figure out a plan, because forbearance and deferment is not a long-term strategy for getting out of debt, to find a repayment plan that you can afford. So you want to review your repayment plans. You want to explore IDR plans that you may not have originally explored. Again, request the additionals and deferments and forbearance if you have no other option, but eventually you're going to have to figure out something. Okay, if your loan is in default, what do you do? So after 270 days of non-payment, that's about 9 months, your loans are at risk of default. Once you're in default, the debt becomes payable in full immediately, which of course is a non-starter for most people who are in default. You are no longer eligible for IDR plans, for deferment, for forbearance, and you can't earn credit towards forgiveness programs, nor can you get access to federal aid if you're looking to continue your education. But the biggest problem with being in default is that you are then subject to involuntary collections. And involuntary collections had been suspended for a good 4.5 years throughout COVID, and there was a post-COVID period where they did not click turn the collection switch on either. Earlier this year, the administration announced that they would begin involuntary collections. There's basically three ways that the government, three main ways that the government can can do collections, and they can do this administratively, meaning that they do not have to bring you to court. They can intercept your tax refunds, and this in fact did begin earlier this year. For anybody that submitted their 2024 taxes and already got a refund, that's not going to be clawed back. But if you continue to remain in default, you could be at risk next year. They will also offset your Social Security, which is really horrendous that they do this, but they can take 15% of your Social Security, and they can't leave you with less than $750 per month, which is way below the poverty level, obviously. They announced earlier this year that they were going to start collection the Social Security offsets in June, and then they put it on pause. We have not, to the best of our knowledge, we have not seen any new notices come out. They have not turned that back on just yet. Administrative wage garnishment, they can garnish up to 15% of your disposable pay, which nobody wants to happen. They did say that the notices were going to go out at the end of the summer. That has not happened yet. I guess the key thing to say here is that even though a lot of this has not happened, they could switch this back on, at any time. So if you're still in default at this point, you want to take this little bit of a hiatus, however long it is, to maybe make some arrangements to get yourself out of default before all of this happens. The government, by the way, can also intercept funds that are owed to you from federal contracts or the sale of federal assets, so things like treasury bonds. We've heard reports of people selling treasury bonds and then they never received the proceeds because the government just took them. If you're not sure whether or not you're in the queue to for an offset, you can call this Treasury Offset Program or Top Line. This is for the individual has to call, not the not an advocate. You give your name and your Social Security number, and it'll tell you whether or not you're scheduled for an offset. And then if you are in default, just remember with federal student loans, there are ways to get out of default. There are some people that may not be eligible for either of these things, but for the most part, most people will be able to avail themselves of one of these options, either loan consolidation, where you just replace your old defaulted loans with a new loan, or loan rehabilitation, which is a process by which you make 9 qualifying payments over a 10-month period, and that will bring your loans out of default. Now, it's difficult to say what the best option is. I think if you're in default, the best thing to do would be to contact somebody and go through the options, see which one makes more sense. Generally, consolidation is going to be faster and cheaper than loan rehabilitation, but there are certain circumstances when either you can't do it, or it just might not be the better option for you. Now, if you have an administrative wage garnishment in place, you cannot do a loan consolidation. You would have to somehow get that wage garnishment set aside in order for you to consolidate your loans. A loan rehabilitation can stop a wage garnishment, however, after you make 5 payments in the loan rehabilitation. You cannot, by the way, do a loan consolidation or a rehabilitation if there's an outstanding court judgment on your loans. That would be a different issue where you would have to seek some legal advice. The one thing about loan rehabilitation, even though this may not be an option for you right now, there's a possibility, well, it should be an option in 2027 when the new rules change. And that is the end of the presentation. So this is the contact information for LSLI to reach out for one-on-one assistance. And I'll just throw it over to Vivian and Allison to see if there's any last questions that we want to address.
I don't see anything else in the chat for now. So maybe give people just a second or two to see if anyone starts typing.
Okay.
Hey, if Nancy, could you put up our contact information again? There was a question about how to set up a private appointment.
Yes, I will do that. And just also remember, you're going to get the deck. I'm trying to find, oh, there we go.
I just put our phone number into the chat as well. Or I think people can email. I don't know if you have this on it. I'll put this on.
Let's see. There we go. So I don't see the email on here,
and then
but
that final page. Right. And you can ask you just say EDCAP, that you're asking to speak to EDCAP, or you can mention either me or Allison by name. I'm Vivian Storm. Okay, I think that's it. Thank you so much, Nancy. This was a lot of fabulous information.
yeah, it's a lot of information. I know it's a lot to you know, digest, but there are people to help you refine it. Okay, thank you, everybody. Have a great day.
Thank
Bye.
you, everyone. Have a great day.
Bye-bye.
Thanks, Nancy.